Okay. I'd like to call to order the Cuyahoga County Council Committee of the Whole for Tuesday, March the 18th, 2014. Since we all survived St. Patrick's Day, we're ready to proceed. You want to call the roll?
Calling the roll. Mr. Gallagher. Mr. Gallagher is absent. Mr. Schron. Mr. Schron is absent. Ms. Conwell.
Here.
Mr. Jones. Mr. Hairston?
Here.
Ms. Simon?
Here.
Mr. Greenspan?
Here.
Mr. Miller?
Here.
Mr. Brady? Mr. Brady is absent. Mr. Germana?
Here.
There is a quorum. Oh, Ms. Conley.
Here.
I'm sorry.
There is a quorum. Is there any public comment related to the agenda?
Yes, Madam Chairman, there is. Tim Russo.
All right, Mr. Russo, you have 3 minutes.
Thank you, Madam President. Many in this room will remember that in 2000, I hosted a delegation of my British Labour Party colleagues who visited Cleveland to volunteer for the Al Gore campaign for president. We worked together during the 1997 Labour Party campaign of Tony Blair. Some of them had joined me in the former Soviet Union, training political parties and election observers in Russia, Ukraine, Armenia, and Georgia. We shared a stunned disbelief that my friends left for Britain a week after the 2000 election, still with no result. When Bush v. Gore stopped ballots being counted for president of my own country, suddenly everything I said in front of seminar rooms packed with former Soviet apparatchiks seemed like a bad joke. Since 2000, I've watched in sadness as the methods of electoral manipulation I witnessed as an election observer abroad have proliferated in the United States. When I trained Kerry Edwards' political party challengers in 2004, I couldn't believe I was training 300 lawyers in my own hometown without the need for an interpreter. Cartoonishly stuffed ballot boxes aren't the only way elections can be manipulated, just the most oafish and clumsy. The best electoral manipulation is highly sophisticated, done in plain sight, with a total disregard for consequences, in service to moneyed interests seeking to purchase power. Today, the electoral process in America and Ohio has become a plaything of the Republican Party with the shameless hue of Jim Crow, as if John Huston never heard of the Freedom Rides, Medgar Evers, or the Edmund Pettus Bridge. John Huston very purposefully is toying with our American inheritance with the sole purpose and effect of disenfranchising African Americans. Huston's mother should be ashamed of him. Since 1997, I've fought to expose and end these practices in nearly a dozen countries. Now that fight has come home to my own country. It falls to us to place ourselves between the vote and the sharp end of the 1%'s endless greed, their lust for total control of our political process by virtue of their money alone. John Huston is the 1%'s cheap stooge, a reliably enslaved golem, crawling about naked, shivering, and shriveled in perpetual search for the ring. For one glimpse of the ring, John Huston will spend every effort, every minute, reducing himself to a withered ghost drooling over his precious, destroying every single thing of human value standing between him and slavish devotion to the ring. To keep the 1%'s grip on power, John Huston will scurry at the ring over the graves of every American who ever fought for our precious human right to vote. In a society governed by money, of money, and for money, John Huston isn't the only golem, he's just the one with the sharpest teeth. We are human beings, not human resources. Money must not govern us. We must govern ourselves. I support this resolution as a candidate for county executive, a voter, an American, and a witness to precisely the same crimes against experiments in self-governance all over the world. Thank you.
Thank you, Mr. Russo. How many times did you go to the thesaurus for that? Okay. Anyone else signed in for a comment?
Madam Chair, no one else has signed in.
We have 2 items on the agenda for the committee of the whole. Both items were referred from council. And the first item is a treasury matter, but we're going to defer and take item B first. Mr. Fitzgerald asked to make some comments, and we're going to defer to him. He has to be out of here at 2:30, I believe. So I need the clerk to read it.
Ordinance number 2014-0008, an ordinance enacting the Cuyahoga County Voting Rights Law, updating the Cuyahoga County Equity Plan in Chapter 1101 of the Cuyahoga County Code in conformity therewith, and declaring the necessity that this ordinance become immediately effective.
Mr. Fitzgerald.
Thank you very much, Madam President. I had some prepared remarks. I'm going to amend them a little bit. I had some Lord of the Rings references. Let me just cross those out. Okay. It's impossible to talk about this issue of voting rights here in Cuyahoga County without talking about what happened in Cuyahoga County. We're not discussing this as some kind of intellectual exercise. We're not even talking about it as a theoretical civil rights issue. We're not even talking about it the way that the New York Times editorial board might talk about it, because they don't live here and they didn't experience it. We have to begin this discussion by talking about how did we get here in the first place? And it came out of the 2004 elections. That's how this whole conversation started. We weren't having this conversation in the 1990s or the early 2000s. The conversation started really in earnest for Cuyahoga County in 2004. Why? Because we had chaos at the polls. And Ohio became known, unfortunately, as a place that didn't know how to run a proper election. The estimate is 175,000 people in Ohio wanted to vote and didn't get an opportunity to vote in 2004 because of chaos at the polls. We were ground zero for that in this county. It happened. I talked to people that were waiting in line until midnight and beyond. So all of us who are in elective office or just citizens or observers at the time know that that's what happened. Now, if you forget that, then this becomes this whole discussion about, well, do we really need this much voting? When we didn't have expansive early voting, 2004 happened. That's a fact. So we have to start with that and accept that as a premise for the discussion. The changes that were made to voting laws, I must say it was one of those times where there was a bipartisan consensus in this state where the problem was identified, the problem being this chaos at the polls, and the fact that particularly, although not exclusively, but particularly in big cities like Cleveland, you had unacceptably long lines and chaotic situations, which was effectively serving the effective purpose of denying people the right to vote. So the bipartisan consensus emerged that we would fix that. Well, the good news is it's one of those rare times where in pretty short order, elected officials identified a problem, came up with a solution, implemented it, and it worked. The problem was identified in 2004. A solution was proposed, and the solution was to make sure that we didn't have this enormous rush of voting on election day, which would be a particular benefit to reducing congestion at the polls in urban areas, and that the solution would be that we would have expanded voting. And we have ever since then, and we haven't had a repetition of 2004 ever since. We know that this works because the people that all of us represent and all of us were elected by, all of us were elected in part by people who were casting their votes in person and using early voting, whether it's in person or by mail. All of us, every single person that's going to deliberate on it. Now, there are certain council districts that have used it more than others, but all of us have a common duty to make sure that our electoral system works for us. Now, starting after 2010, things started to change. After the 2010 elections, there were efforts, and we saw them in 2011 when this administration, all of us collectively, took office in 2011. We saw things started to change, and what started to change was after the 2010 election, there were efforts in a number of states, including Ohio, to start to take away early voting. Not because of fraud, because we've had virtually no instance of voter fraud here in Cuyahoga County since these provisions were added to state law. And I'm very proud that one of the things that we did in 2011 was when it looked like we were not going to be able to have early voting by mail, this council and the administration took the step, the extraordinary step that no other county did, by the way, to say we are going to vote by mail applications, not ballots, but applications to every single registered voter. Until we did that, until this administration and council did that and appropriated money to do that, we would not have had the distribution of absentee ballot applications like we ended up having in 2012. We were not on track for that. There was no plans for the state to do it, and the state was taking away the ability of local boards of elections to do that, even though they had been doing it successfully for several elections, very successfully in this county. It wasn't until this council and the administration took that step back in 2011 to say, no, we're going to do that, that the state reconsidered. And if this council hadn't given me the authority to do that and the leverage to do that, we never would have gotten the result that we ended up getting, not just for our own residents, but for residents all across the state. Because what happened was after we did that, I sat down and negotiated an agreement with Secretary of State Husted, where although we did not have absentee ballot applications mailed out in 2011, there was a commitment to do it in 2012, when we knew, again, there would be a huge crush of voters at the polls. And that was the agreement. And it was an explicit agreement that was made. I spoke to the Speaker of the House, Batchelder, at the time. They made a commitment to Cuyahoga County that those funds were in the budget, and we would be able to mail those out, or the state would be able to mail them out to every single voter in the state. And I thought that was great. Now, why do I reference that? We have to know the history of how we got here. 2004 is important. All the expansions that were done up until 2011, what was important? The attempt to take away Board of Elections' rights to mail out absentee ballot applications in 2011 was important. What our response to that, and the fact that we took that unilateral action, gave us the leverage to negotiate that deal. If we did not have the authority to do that, we never could have negotiated that deal in the first place for voters in 2012. So now we go into 2012. What happens in 2012? Well, absentee ballot applications go out statewide, very popular, used all over the state. What else happens? Well, in the weeks running up to the 2012 election, the Secretary of State's office tried to restrict early voting. And there were a number of entities that ended up suing over that in federal court. And the federal court ruled very decisively that that was a violation of federal law, that they shouldn't be changing the rules in a way that was discriminatory and restrictive to voters. Again, our county was on the cutting edge of that because we were the only county to file an amicus brief, which, as you know, Madam President, sometimes you wonder if an amicus brief is read by a court or not, because they can get quite a few of them. But our brief that we submitted about how important that was to Cuyahoga County and how it's affected residents in our county was cited by the federal court as a linchpin, not even just parenthetically, but as a linchpin of their decision, finding the Secretary of State's action to be in conflict with federal law. Now we come to 2013. It's the same playbook. It's been done in state after state after state, and now it's being done here again. There are 3 bills that the legislature passed. The governor signed all of them: Senate Bills 205, 216, and 238. And then on top of that, you had the Secretary of State Directive 2014-06. What is the net effect of these? It's eliminating about 6 days of early voting. It's eliminating Sunday voting. It's eliminating in-person Sunday voting. It's eliminating in-person evening voting the week before the election. It is also taking away all local communities' rights to mail voter applications, absentee voter applications. And I'll get to that in a minute. Now, who is this affecting? Well, we know exactly who it has affected in the past, because we know that in 2008, here in Cuyahoga County, which has an African American population of 29%, we know that of those individuals who voted in person, early voting, whether it be on Sunday or the weekend hours, the week before the election, 78% were African American. We also know from other studies that have been done that the people who end up availing themselves of that in-person early voting are predominantly working people and the poor. I know there are some people who say, well, just voting on Tuesday was good enough for my grandfather, it's good enough for me. We know what the effect is of only having voting on a Tuesday. We know that in this county it can cause horrendous lines where people end up actually losing their right to vote. We also know that it is tough for a person who is working 2 jobs or 3 jobs, or has to work a double shift, or has to pick up their kids at school and at daycare and juggle a couple different responsibilities. It isn't always possible for them. So it's easier for a person who controls their own schedule or is their own boss or to vote on a Tuesday. And we know that because our own residents have been telling us that they like this. How have they been telling us? By doing it. So I don't know how much the council people have heard from their constituents. I guarantee that you will hear from them once most of them realize they can't do it again. The other thing that's so important, it's not just important as a matter of customer service or convenience, it's also a legal principle that the rules of elections are supposed to be consistent. The fact that we're giving people Sunday voting for a while and then saying, no, you don't have Sunday voting anymore. And, oh, you can vote in the evening hours. No, you can't. Now you can't do it, is disruptive because it's unpredictable. And again, especially for people who maybe they haven't been at the same address for the last 25 years. It's the other thing that tends to affect low-income folks in this community more than folks that have a little bit more financial resources. They may not be at the same address for 25 years. They may have been evicted. They may have had to move a couple times. That causes problems, but it shouldn't cause them a problem in terms of exercising their right to vote. Why is this legislation important to pass? Well, first of all, it's important for us to, I believe, establish by ordinance that this is one of our core principles that we believe in and we stand up for it. We have done it consistently through this whole administration, and I think we should codify it into our law. Secondly, I believe it belongs in both our ordinances and our charter because it will strengthen our hand in any litigation that we may pursue. And our law director can go into greater detail about how we are pursuing legal strategies. We took a risk, I suppose you could say, when we mailed those ballots back in, or we gave ourselves the capacity to mail the ballots, we didn't have to do it, back in 2011. It is not a coincidence that this legislation is trying to take away the rights of local communities, local counties, to mail ballot applications. Because if their intention was to continue to have the state mail out those ballot applications, there's no need for the county to do it. We're not going to mail out ballot applications if the state mails out ballot applications. So there's no reason to take away local counties' ability to mail out ballot applications if they're going to continue to do it. But see, the thing is, they have not committed to continue to do that. They're funding it one election at a time, and they haven't said whether they're going to continue to fund it. So what happens for the 2016 elections if the legislature says, we don't have the funds, times are tough, we can't afford to mail out the absentee ballot applications? Can Cuyahoga County say, well, if you're not going to do it, then we're going to do it? No, we won't have the ability to do it anymore. Can whoever the county executive is and the county council people at the time go to the state and say, if you're not going to do it, we're going to do it, we insist you do it? No, because that leverage will be taken away from us. The deal that we struck in 2011 would be impossible if that legislation had already been passed. So I have to give them credit. They're not just dealing with the immediate voter suppression, they're also, in this legislation, this was pointed directly at this county because this county actually took an affirmative action that gave us leverage over the state and forced them to mail ballot applications for the 2012 election. We won't be able to do that, and neither will any other county be able to do that if this legislation passes. Now, I'll just say this, and I appreciate you being, I'm actually, I have a few more minutes here. I'm actually meeting with some people in other parts of Ohio that are also contemplating legal action on voting rights issues. I can inform the council, though, that there are a number of communities that are passing, that I believe will be considering, and I hope passing, supportive resolutions about the stand that I hope we will take. That includes the city of Cleveland, and it includes, I know Cleveland City Council is going to be deliberating on this, and it also is going to include some other suburbs in this area, and I think it'll include some other cities. I think it'll include most major cities that this has affected in the past across Ohio, and I think you're going to see that in the next few weeks. I would mention one other thing, though, that we're doing in terms of preparing ourselves for litigation. I mentioned the statistics of the 78% of in-person voters in Cuyahoga County, early in-person voters being African American back in 2008. It's very important to document that discriminatory effect. And look, I will use much less dramatic language than the gentleman previous to me, because in a way, I don't care what people's motivation is. I can't see into their heart, but what I do know is I do know what the effect is. I know what the effect is. I know what the effect of these regulations were in 2008. And what Mr. McCloof and our legal team is doing is they are collecting information to give this body and the public just objective information. Who was using early voting in the 2012 elections? And Mr. McCloof is collecting that information not just for Cuyahoga County, but the other major urban centers. I think that information will be helpful to the council as you deliberate about this. I think it will also be instructive to the public. I believe that a lot of the people that instituted these new restrictions know that information, by the way. I don't think they pass restrictions on voting without knowing their political impact. I think you'd have to be very naive not to know that. But we should reach a point in this country and in this state, and I know we've already reached this point, at least I believe we reached this point in this county, where voting issues are not who wins, it's whether or not every citizen has a free and fair chance, regardless of their zip code, economic status, race, whether everybody is being included the way that we have to. It's not a theory. All we have to do is go back 10 years. We know what happened then. We owe it to our constituents to make sure that we do not have a repetition of that disaster back in 2004. We have the tools that we know the tools that we have to prevent that, and we should codify it in our ordinances to make sure that continues to happen. I'll just say one other thing, and then I'll stop, and that is empowering us to do this does not necessarily mean that we're passing a law that's not enforceable. It may be a law that we never have to exercise our ability to mail out absentee ballot applications. We'll have to see what happens with the state. But as somebody said, well, somebody had asked me, I think a reporter had asked me, aren't you passing something that's in violation, an ordinance that would be in violation of the law? Our opinion is that the state law is in violation of existing federal law. And if we had taken that same approach back in 2011, we never would have made the progress that we did. Thank you very much. Thanks for your patience, Madam President.
I know there are a number of questions, but you are getting ready to leave, or you have to leave?
No, I could be here for a few more minutes, and then I didn't know if Mr. McCloof wanted to, whatever the council president would, if there's questions specifically for me, I'm happy to stay until there's any questions specific to me.
Okay, I know there are a number of questions, and I know Mr. Greenspan's number of questions. Mr. Germana is usually shorter in his questions, so why don't we start with Mr. Germana, and then we'll go to Mr. Greenspan.
And Madam President, the executive doesn't have to be present for mine, because I can direct them to the law director for response.
Okay, all right. So if anyone has a question specifically to Mr. Fitzgerald, you want to go ahead, Mr. Germana?
Well, just to be brief, does the state fund our Cuyahoga County Board of Elections in any way?
Well, in some respects, and in some respects we do. It's kind of they're kind of a hybrid creation of statute, but most of the expenses following us. I can have Mr. McClure give you a more detailed answer, but I will tell you that one of the arguments that was made back in 2012 was that they wanted to eliminate early voting because it was a burden on local communities. And that argument has been repeated this year, that they're doing us a favor. So what our brief, we made some other arguments in our brief back in 2012, Councilman, because almost identical issues, a lot of the same issues back in 2012. The court invalidated some of those restrictions in part because they were done close in time to the election. So part of what you have is you have the state now taking some of the same actions that were overturned by federal court, just doing them a little bit sooner. But they've made the same argument this year, that this is just a cost savings. One of the things that we documented in federal court is we said, we're the biggest county in Cuyahoga County, and we have budgeted for this. And this is a service that we think is worth it. We're not asking, I mean, can you imagine of all the ways to save money, you're gonna save money by cutting back on voting hours? That was never anything where we were saying that was burdensome. Now, the state has an over my other argument would just be, the state has an over $60 billion budget. If they want to subsidize this, if they believe that it is a burden for small rural counties, because they have said that every county has to have the exact same thing, even though we dispute that every county has to have the exact same hours, because there are some counties that don't use in-person early voting like Cuyahoga County does. And so for some of those rural counties, they've said, we don't want this and we don't want to have to pay for it. I would say two things. Number one is, if the county doesn't want it, I mean, to me, that's home rule. They don't want it, they don't want it. And I think we could look at that issue, or the state could look at that issue. The second thing is, the state has shown the willingness before to pay for those things that they think are basic responsibilities of boards of elections. So when we said we would pay for our own early ballot applications, they said, no, we'll pick up the cost for that. So they can use sometimes federal funds. There are federal funds that are sometimes available to increase ballot access. As a matter of fact, they use what are called HAVA funds, Help America Vote Act funds, they use those funds directly to mail out absentee ballot applications for the 2012 elections. So I would just say, look, you decide what you need to conduct a fair and effective elections, and you fund that. You don't say, well, this is what we need, but we can't afford it, because this to me is one of the basic functions of government. It might be the first basic function. The first function of government ought to be to conduct an election that's going to be fair. But Mr. McClure, you can expand on that.
I just wanted
the funding issue anyway.
To follow up exactly is, pursuant to the Ohio Revised Code, we fund completely the Board of Elections. So the Board of Elections, it's provision 3501.17. The county funds the Board of Elections. And with respect to the issue of uniformity, it's, courts have addressed this issue, and the requirement under the U.S. Constitution is equal protection. It's not uniformity. And courts have recognized that actually uniformity can very much result in inequity. So by saying that you want to have a uniform system, you have counties of different sizes, and you have a cookie cutter method, regardless whether you're the smallest counties or the largest county. You end up having 8 hours of voting lines in Cuyahoga County and no voting lines in smaller counties. You're actually resulting in inequality. So that's the issue that it's very critical not to confuse. What you need to achieve is equity, not uniformity. Uniformity, the cookie cutter approach, can very much result in inequity.
That's exactly right. In 2004, and I'll keep harping back to that because there's this tendency to, again, think about this issue in a vacuum as if 2004 didn't happen. We had a uniform voting system by the Secretary of State's definition, or the legislature's definition, in 2004. It wasn't uniform in its effect, because if you lived in a big city, you didn't have the same experience that you did in a rural county. There's counties in Ohio that only have 16,000, 17,000 people in it, in the whole county. And so you don't have, we know they didn't have the same experiences because if you look at where the voting, if you look at the voting booths that were, or the polling stations that were open till 2 in the morning, it was all in the urban areas, which is why they said, yeah, we've got to adjust this to fix it, to make sure that it's just as easy to vote in an urban area as it is in a rural area.
Madam Chair, the reason I asked that question, and I assume that each county funded its own Board of Elections. I just wanted to say that for the record, so that was a long way of getting that out. But not all counties are created equal. And in some counties, because of population and precincts in the major cities, I think what the state should be doing is having the lowest standard legally, not the highest, because government closest to the people is best because they know what the situation is. So, you know, there's a lot of these counties that they don't need on Sunday voting and so on and so forth. But the counties should be able to grant what kind of services they need to produce so that there is efficient voting of anybody that would like to vote has a chance to vote. And so I think the state standard should be the minimum common denominator, what every county at the least should offer for voting, not put a lid on what counties want to produce, because the local officials should be making that determination as to what we need. So that was my question.
And Council President, if I could just in response to that, to me, one of the minimum things that we should have in this county or any other is that if you're a registered voter, you should be mailed a vote by mail application. And it would have been as easy as this in the legislation. They could have added one line and I wouldn't have had any objection to it at all. They could have said, local boards of elections cannot mail out absentee ballot applications unless the state fails to do so. That's it. So if they want to do it and they want to make it universal, that's fine. But if they don't want to do it, we still have a responsibility to make sure that our residents have that option. They didn't do that. They have not committed themselves to that basic level that you're talking about. They're not committing to that. They're opening the door for 2016 to not mail out absentee ballot applications, and there won't be a thing that this county will be able to do about it.
All right, Mr. Greenspan, like 2 questions or is there anything, because do you have to leave?
Go ahead, man. Go ahead.
In respect to the executive's time, these aren't necessarily directed towards him. These are
Okay.
just questions that I have regarding this and regarding the 4 corners of the document. So if there are other members who would like to ask the executive, I'd like to direct him to him, but being respectful of his time. So if
No,
there are other
just-
members that,
I'll go when I have to go, but I'm okay with it.
Okay.
oh, okay, all right, great. Well, then let me just, first of all, start by saying, as I was then, I am now a supporter of early absentee and in-person voting. So I understand and am a supporter of that concept. But I want to direct my comments not to what the legislation that another body enacted, but the legislation that's before us. Because to me, that's the germane issue here, and the item to which we have an opportunity or don't have an opportunity, depending on how this moves, to have an effect on our residents. So I've made a number of notes, and they're all kind of intertwined as we move through this, and I'm just moving through the ordinance itself. But as I understand in 2004, and I acknowledge I didn't live here in 2004, but
If all those people that voted in 2004 had been Chief Justice of the Supreme Court.
the difference between the election process in 04 and 2012, or even today, is significantly different. And as I understand it, there was 1 day of voting in 2004. There was the opposite of no fault, or absentee ballots. and the state had implemented new machines, which very well may have all contributed to the issues that occurred in 2004. And rightly so, the state did move in a direction to alleviate a lot of these problems. But I think it's important when we refer back to a period in time and the lines and so forth to also understand the when we're all in college English and they talk about compare and contrast the story, I think we need to understand the compare and contrast of the voting environments during those times. In the ordinance, and I'm just going to move through this, on page 3 in the second whereas, it talks about and refers to our county's equity plan, and it refers to voting. And I read through the provisions that are listed here, and although I didn't see the word voting listed anywhere, it is important to note that we all supported this equity ordinance, and I supported it then and I support it now, in particular when we talk about equity and fairness, justice, and the inclusion by and among people, and across all socioeconomic, political classifications, regardless of race, color, religion, sex, national origin, sexual orientation, including gender identity, disability, age, or ancestry. I think we all agree with that. We all believe that. And it's a value that I believe this county has embraced. With that said, I have a question when we talk about equity and understanding that our ordinances only pertain to Cuyahoga County, but the concept of equity is a concept that should go beyond county borders. And I believe that we believe that as well. The issue or the questions that I have to do with general equity in voting. And what I mean by that, and I'm talking only of our ordinance, let me get the document I have here. This ordinance would impact Cuyahoga County voters only, but the ordinance has an impact on 16 counties in Ohio because of the cross-county districts. Whether you're talking about municipalities, whether you're talking about school districts, congressional districts, and that in itself, if you embrace the concept of equity and providing that an election itself is held to where the voters, all voters voting in that election, have the same opportunities to participate in the process, then I challenge the concept that this ordinance very well may be in violation not of the letter of our equity ordinance, but clearly the spirit of what equity truly is, especially when the ordinance itself relates back to voting. I do have a question. So that's a concept point that I think is a challenge within this ordinance. The question of home rule. And I know that this ordinance talks about home rule a number of times. And as my colleagues know, I try to do my homework as it relates to understanding legislation, especially legislation as important as this, and as the executive said, is fundamental to our nation as it is listed in the United States Constitution. In the discussion of home rule, and Mr. McClue, and this will be a question, not to answer now, but at a future, expect a response at a future date. In Article 18, Section 3 of the Ohio Constitution, it says municipalities shall have the authority to exercise all powers of local self-government and to adopt and enforce within their limits such local police, sanitary, and other similar regulations as are not in conflict with general laws. And I also noticed that in the first now therefore, it reiterates, I believe it's there, it reiterates the same general concept. It further goes on to say, and this goes back to my previous point regarding the impact that this would have on various, the 16 other counties to which we share cross-border elections. The power of self-government, and I can tell you where this is at a later date. The power of self-government granted to municipalities by Article 18 relates solely to the government and administration of internal affairs of the municipality, and in the absence of a statute conferring a broader power, municipal legislation must be confined to that area. Where a proceeding is such that it affects not only the municipality itself, but the surrounding territory beyond its boundaries, such proceedings is no longer one which falls within the sphere of local government, but is one which must be governed by the general law of the state. So if I'm reading that and interpreting it into this legislation, it appears that because we have this cross-boundary, cross-district election process taking place, that the assertion of home rule may not be allowed. And so if I don't need an opinion now, but I would like to know if I'm interpreting that correctly. Just
Madam
move-
President, if I may just quickly address just one issue, which is the comparison to 2004, because I think there is a very important fact that's missing from the analysis that you just mentioned, which is the Board of Elections, in reliance on these new procedures that were enacted in the aftermath of 2004, reduced the number of precincts available in the county. And if you notice in the last election, a lot of us, our voting places changed. So we now have less places to go vote than we even had in 2004. And that was in reliance on citizens' ability to vote by mail. That was in reliance on citizens' ability to vote early at the Board of Elections, to vote during the weekends. And that is a very critical fact that you can't ignore. Critically also, one more very important fact, which is something that happens to be more, wouldn't use the word unique, but more prevalent in Cuyahoga County, which is the multi-precinct voting locations. I think it's 94% of our voting locations in Cuyahoga County are multi-precinct, which is where the largest area of error can happen when our voters go to vote and they're directed to the wrong precinct or something of that nature happens, and then they're relegated to a provisional ballot that may never count. So those are things that are unique to Cuyahoga County that we should have the power to address. With respect to home rule, I can go into much more depth about that, but I would say home rule has been interpreted by case law for years and years and for decades. It is much broader than what you're saying, but I think it's critical to also realize what we're saying. We're not directing the Board of Elections to send these applications to vote by mail. So that's not what this legislation does. The state legislation only prohibits governmental entities from mailing the applications to vote by mail. It doesn't prohibit private parties or other parties from mailing that application. So if you have Eaton Corporation or Goodyear or whoever, tomorrow they want to mail the applications to vote by mail to whoever they wish. They have the legal power to do it under state law as amended, without any limitation, and they can mail them with postage prepaid return envelopes. If you have candidates with financial resources that they want to mail those applications to their voters, their specific voters, with postage prepaid return envelope, they have the power to do it under state law as it currently stands. What we're saying is there's a First Amendment issue. When you become a home rule entity, you are now a separate entity that is entitled to rights and privileges as that home rule entity. And one of those rights and privileges to which we're entitled as a home rule entity is First Amendment rights. And we have the right to communicate with our citizens and to communicate information to our citizens. So home rule gives us the right to do what other similarly situated entities are able to do. But even the area of home rule, it's when you're regulating the public, and we're not regulating the public here, but again, that's a whole line of case law that can get quite complicated.
Okay, thank you. Just further to that, and I believe, I'm going to comment only what's in here. I'm not going to go expand beyond that. But further what's in here, maybe the law director can give me an example. There's language here pertaining specifically to the 19th Amendment of the U.S. Constitution, where it talks about the rights of citizens of the United States to vote shall not be denied or abridged. Abridged in this context is to amend or change, correct?
Limitation on their ability
Limitations.
to exercise.
Okay. And it says, further goes, by the United States or any state, and I'll leave it there. But if the state law, which I'm going to talk about in a minute, is already in place, then are we then not abridging those rights from the state? The Constitution doesn't refer to counties, but it says the state to the United States. I would presume the county to the state. And I'll talk about more about where I'm going
But I
with
would
that.
just mention that,
Yeah.
that you're flipping the amendment upside down. The purpose of that amendment is that the state can enact laws to abridge the ability of citizens to exercise their rights to vote. It's not that we are infringing on the state's right. The whole purpose of the amendment is to, not to be able to impose things like poll taxes or interfere with citizens' ability to vote. That's the purpose of the amendment, not the other way around.
Okay, well, let me move on to, and I appreciate that explanation. Let me move on to the actual, now therefore, under the program benefits. Can I get an explanation as to what is referred to by provision A, or subsection A, where it talks about promoting and implementing voter registration, including through services provided by any division of the Department of Health and Human Services? What is the intent there?
We recognize that the county we provide a lot of services to our citizens and a lot of interaction with our citizens. And that is always an opportunity to encourage our citizens to register to vote, including when we provide services through Health and Human Services. And quite frankly, some of this is already required by the voter law, under, so the ability is when we're providing, be it citizens come to sign up for Medicaid or any other provisions, when we have interactions with our citizens, we will put in place procedures to make sure that we encourage them to vote. We provide them with the ability to register to vote and facilitate their ability to register to vote as part of providing our services to the constituency.
So it's no greater expansion to the HAVA provision?
Well, it could be greater than HAVA because we're making sure that it happens at every step in which we do it. HAVA, goes far, but this could go much further, and I can have Dave Merriman even go into more details about that. But yes, we can go further than HAVA. That's what we're trying to do.
If I could just add quickly, the county has done that, but I would say sporadically when we and I don't think as well as it could have. There are other. Again, it's adopting a philosophy that when we interact with the public, it should be a service that we consistently offer. Now, we have done it in some departments within Human Services, and David Merriman can provide to you when that has happened before. But it's part of a philosophy that we think the county should adopt, that we should do it whenever we can. And by the way, not just, we should encourage that in the private sector too. This was years ago, but at one point in Ohio, McDonald's decided to provide voter forms with every single time they used it as a tray liner when they would serve food because they were asked to by the Secretary of State at the time. So it's just consistent with this that it should be something that where we're constantly reinforcing that whenever we interact with the public, as long as it's practical and not overly burdensome to either the consumer or the customer and ourselves.
So this provision doesn't purport to expand the HAVA guidelines?
Well, I think, again, clearly read what it says. It says promoting and implementing voter registration at all levels of citizen interaction with county government, including through services provided by any division in HHS. So it is not, it's expanding it beyond HAVA is that it's at every level of interaction. One of the HAVA is listed as an example, but that's not the only limitation.
Okay. Moving on.
It's almost like Councilman Germana mentioned, that's the floor. We're trying to go above it. That's not the limit.
So moving on to the next paragraph where we talk about promoting and mailing out the ballots. In 2014, I'm sorry, we're talking about the request for absentee ballot. In 2014, the Secretary of State has agreed to mail out the ballots. In 2015 is when the provision kicks in that, I'm sorry, so in 2015 and beyond, as the law that was passed in Columbus states, the Secretary of State can request and approval of the appropriations from the legislature to provide that service. So if the Secretary of State is mailing out in 2014, is it the county's intent to mail out in 2014?
I think it completely depends on what the state is doing. And again, it's critical to understand what the state law says. It says that the Secretary of State can mail it if it's been appropriated. Just because the Secretary of State says, I want to mail it, that's not a binding commitment that the Secretary of State will actually mail it in 2012. The other issue where this can come up, and it did actually happen in 2012, even though we had reached that agreement in Columbus that they were going to mail the applications in 2011, that they were going to mail the applications, all of a sudden we had the Secretary of State trying to mail the applications at an absurdly early date, when we had to go back and said, okay, if you mail them that early, then we're gonna go ahead and, remember our resolution at the time was pretty broad in the authorizing language, so we could have still done it later. So we threatened that if you mail it that early, we'll still go ahead and mail them in a timely fashion, which made the change in the mailing. So just because the Secretary of State is going to mail it, if the Secretary of State chooses to mail it at an absurd time, we may very well exercise invoke the right to go ahead and
But
exercise our right here.
And that in itself would be a violation of state law, correct?
No, and I just, again, there are multiple areas with the state law. Keep in mind, all the state law says is that governmental entities can't mail the absentee ballot applications. So there are, even within the confines of the state law, there are a couple of ways in which you can still achieve that objective. But our position, state law is illegal. It's unconstitutional. I mean, it has a violation every way you can think of it, from our ability to do it under home rule, to the infringement on our First Amendment rights, to as a county entity, to three, the idea that when you are a state entity and saying you cannot use the U.S. Post Office to mail a document, but you can use UPS or FedEx or hand deliver it. The U.S. Post Office is created under the U.S. Constitution. It's been in existence since 1792.
That's a great line from Miracle on 34th Street. Remember that the lawyer that argues?
Ohio gave up the right to ban us from using the U.S. Post Office when it joined the Union in 1803. The Postal Service Act, only Congress gets to decide what goes through the post office and doesn't go through the post office. The state legislature doesn't get to regulate the U.S. Post Office.
All right, so
I just like to, Mr. Greenspan raises a number of very legitimate questions, and Mr. McCoof is responding, but I would like to have him reduce some of these answers to writing so that we can, I'm taking notes vigorously and you're making some very good points, but I would really like to have essentially a brief in support that deals with the questions that people have raised, and primarily the issue about the home rule. Because, on its face, we're passing an ordinance that appears to be in conflict with the state law. And I understand your position, but I think that we all have to be able to understand these issues clearly and read your arguments other than just verbalizing them. And particularly, the point about the cost of this. Are we doing something that we would have to come back, the auditor would come back and say, well, you did something unlawful, and, we would be even personally responsible for it. So I think that those are some of the questions that we'd like to have from the law department. Now, you've already stated your position on this, and you represent the executive, and you also represent us, so do we need another?
And just for clarity, I represent my position as the law director, my own opinion.
Okay.
This is not something that I'm not representing. When I speak as to the legality of it, I'm giving my opinion. That opinion wouldn't differ whether it's coming from the county executive or the county council. That is my own reasoned opinion as law director.
Well, Madam President, if I can continue then, and just a point to that point, and the law director and understanding your position, and your position is in a delicate situation because you represent both.
Not at all.
But
no, this is an issue that I disagree completely. This is that's the very job of a law director when you rule on legal matters and you give your opinion without regard to who the question comes from. It's not like if the question came from the council, the answer would be different, or if I'm giving you my best reasoned opinion, couldn't care less who the question is coming from.
Okay. Then I'll refrain from my comment that I was going to make. So some of the points, and just to the council president's position, for us to get in writing responses to would be the home rule concept. If you could just clarify the concept regarding provision A under program benefits. Under B, I understand that the Secretary of State will be mailing out 2014 requests for absentee ballots without postage. So if the county doesn't like the date he's mailing them out, it sounds to me like the executive through this, if this was to pass, would unilaterally mail them out in conflict, thus we would be duplicating efforts, let alone possibly being in violation of state law. The item regarding with the postage prepaid return, I believe that's, I'd like your opinion as it relates to 359902 of the Ohio Revised Code on that specific item. To Council President's point regarding are we personally liable, if we recall back in August of 2011 when we discussed this, there was a letter sent from the Auditor of State's office, and then the last paragraph of that letter, which was sent to all of us, it states that the public expects that tax dollars will be spent on matters authorized by law, absent of a demonstration of legal authority which is not identified in the proposed, well, this was going back to the resolution back then, a finding recovery could be issued in your financial audit. So I'd like your opinion on that statement as well, so we fully understand what the ramifications would be on this vote. I'd also like to know, and this in writing, that's why I wanted to keep my comments somewhat brief, is do you truly need this ordinance to file what appears to be a federal lawsuit? Or in the absence of this, will a federal lawsuit not be filed? So that's that question.
Well, we'll allow Mr. McCoof to reduce his
Yeah, absolutely.
position
I'm
to
asking
writing,
these
'cause
questions.
There's some other people have questions, I think.
Right, and that's why I'm asking,
Okay.
not expecting an answer today, but I would like answers to these questions
Okay.
as we continue to
And
deliberate.
I think you can anticipate filing sort of a brief in support of, and then I think you know the various questions that we like answered.
Sure.
Okay, and I'd like to thank Mr. Miller has provided the article from the New York Times. Anyone else have questions? Yes.
Madam President, since you mentioned the article from the New York Times, as a lot of people probably know, my brother resides in New York City, and he says that it's very seldom that the particular behavior of the state of Ohio attracts attention out there, and granted, everybody knows the New York Times is a liberal newspaper, but I think the fact that they would go to the trouble to write this editorial just suggests how serious a matter that we're dealing with, and we've all lived with this for a number of years now, and it's just kind of become part of the atmosphere. But we're talking about very basic stuff, and I appreciate Councilman Greenspan's questions, and I want to hear all the legal answers, and I think that we need to know and understand the legal ramifications before we do something. But the situation clearly cries out that some significant action needs to be taken, and I think it's just up to us to figure out exactly what that is. The question that I had is more programmatic in nature. We're now only about 2 weeks away from the start of mailing applications, mailing actual ballots out for the 2014 primary, and I know, like in my own district, the number of people who have applied for absent ballots, it's just ridiculously low. It's like 100. And in a district with 110,000 residents in it, and I think we've created kind of a patchwork in that sometimes we mail out these applications and sometimes we don't. And the question I have is whether the intent of the supporters of this legislation is that the county would see to mailing out these applications only in the general election of even-numbered years, or would it also extend to primaries? Would it also extend to municipalities? I mean, would we do it across the board, or would it be selectively? Because if we don't do it across the board, I think we're just going to further contribute to pathetically low voter turnouts that we've seen in the elections that are other than the even-numbered year general elections.
No, and I fully understand, and I think the executive went into the issue about consistency. I think we, and I'll defer to the executive on, because obviously, depending on that, at some point, that's a policy question and not a legal question, but you need to have a system and advertise a system and make sure everybody knows exactly what that system and stick to it. I can tell you personally, one of the areas that I had been very concerned about is this postage return, even with the ballot, because our citizens had been used repeatedly. The system that they had is they get out of the blue the application to vote by mail, they fill it out, they send it in, they get the ballot, and when they get the ballot, you know, with the postage prepaid return envelope, they return it. What could happen is when they get the ballot without postage prepaid return envelope, and they look at it and it's an irregular stamp. The reason why our Board of Elections started paying for the postage return envelope is because it's not a traditional stamp, it's a specific number, and we had that issue where people didn't put the right postage on it. You have a voter getting the ballot by mail without the postage return on it, says, you know what, it's not worth the hassle. If I'm gonna have to make a trip to the post office, I'll just go vote on election day. They tried to go vote on election day. Now, because they had pulled a ballot, they're relegated directly to a provisional ballot and having to, you know, how do you sort that out? So I'm very aware of the issue of consistency, and I think that will be for further discussion. We'll get the executive on it. But I think whatever system that is developed, we got to make sure that our citizens know what it is, and you continue with it regularly.
And Madam President, just one more comment to add, which is that there should be a box provided on the application for absent ballots that says, mail me an application for every election going forward, and that there should be a list that automatically gets mailed an application by request instead of it having to be asked for separately for every election. Thank you.
Ms. Simon has a question, and I think we can move on because we do have to give Mr. McCoof time to get to the law library and get all of his.
Madam President, as a co-sponsor, I just have a few statements. It will be fast, it's not questions. I just want to point out that those who want to restrict voting have gone to great pains to justify their voting suppression efforts. First, it was fraud. There's no fraud in the state. Then it's uniformity. We know that counties can't compare by size. Parsing words, twisting words, that somehow equitable is not equitable when we want to maximize voting. 2004 voting experience, we've rectified that by bipartisan efforts. We certainly don't want to go backwards, do we? I lastly want to say our charter gives us home rule. And with that home rule, we can decide as a county, as a council, as an administration, what kind of county do we want to be? Do we want to be a county that believes in expanding voting or restricting voting? Do we want a county that ensures that minorities and working people have unencumbered ability to vote? Do we want to be a county that believes in the Voting Rights Act of 1963? And finally, a county that believes in fundamental and fair and equitable elections? That's the question that's posed to this council. I mean, we can look at the legality of things, which we'll get a memo, a brief from our law director, but if the answer is yes to those questions, then we have the ability to move forward, and I think we have it's incumbent upon us as leaders to move forward to make sure this county stands above politics.
And Madam President, if I apologize, but if just for clarity, because I think this is very, very important for everybody to understand. There are two different worlds that you operate on. There is a world where you're designing an election system from scratch. and other people coming back and saying, does this system go far enough? Is it a reasonable system? Is it not a reasonable system? And that's where sometimes courts and others may be willing to defer and say, okay, you've developed a system that seems to be reasonable. It's quite another thing, completely different, when you have an election system in place and you come after the fact armed with data as to the effect of the changes that you're making, and you start making changes to election law that have a disparate impact on certain segments of your population. I think, I've seen even on Twitter or different, the Secretary of State put out some, nice visuals showing how many early voting we have in Ohio versus New York. Who cares? We know too much for that argument to make any difference. That argument may have flown in 1990s, but now that we know what the voting patterns are, and we have an election system, and after the fact we're going and chipping at specifically surgically removing the parts that tend to have a disparate impact, I think courts will apply a much sharper lens when they're reviewing those changes as opposed to when you're designing a system from scratch. I just wanted to make sure that, that confusion keeps people saying, oh, Pennsylvania doesn't have early voting, or we know too much for that argument to withstand scrutiny.
I'm going to talk about a time sequence, and I think you have the questions, and I think council persons are free to submit other questions in writing to the law director. But we have a meeting coming up on a week from today, and I'm suggesting that we have another committee of the whole on the off week, or do you want to have it? That would be 2 weeks from today, which would be the off week, and then we would have available to vote on the following Tuesday. That sound? Does that sound okay?
We should have it both then.
Have the hearings on each Tuesday?
Only some of us.
Yeah. Let's set it up for 2 weeks from today, and I'll work with Jean and Majid, and we can always notice you on the meetings, okay?
Madam President,
Yes.
just one final question to the law director in his explanations of home rule. If he can also provide examples, other examples of areas of home rule that the council may be able to operate under. Thank you.
Okay. All right, so we're tentatively talking about 2 weeks, which is the off week from the council meeting, okay? And then if it passed out, then we've got the next meet with the next week to vote on it, so. All right. April 1st. Okay, April 1st, okay. All right, thank you. Let's move on to the next item. So we'll keep this matter in committee. And we're paying Mr. Applebaum by the hour, so we gotta get him going.
Actually, he's on a flat fee.
Okay, all right, let's move on then to item A on the agenda. And Madam Clerk, do you want to read that, please?
Yes, ma'am. Reading into the record, resolution number 2014-0064, a resolution declaring official intent under United States Treasury regulations with respect to reimbursements from bond proceeds of temporary advances made for payments in connection with the development of the county's convention center hotel prior to issuance of bonds and related matters, and declaring the necessity that this resolution become immediately effective.
All right, thank you. And Mr. Huth.
Thank you, Madam Chairman. Greg Huth, Assistant Prosecuting Attorney for the county. First of all, I want to thank you for bringing this resolution forward to this meeting. There's a couple of kind of basic things I want to cover as far as this resolution goes. First of all, this does not commit us to doing anything. It's only expressing the county's intent to do something in the future. So we're not tied to doing anything here. The second thing is you don't see these very often in bond resolutions, but in this case, as I'm sure you've heard, this project is moving pretty fast. And there are some expenses that have gotten out ahead of when the bonds are going to be coming before you for authorization. So the Treasury regulations require that in order to reimburse our general fund for some of the costs that we've recently paid, we have to have this declaration of intent in place within 60 days of when we paid those costs. Now, in this case, we paid Turner near the end of February, around February 18, I think, as part of the demolition project that's going on across the street. So we wanted to be sure that this resolution got in here and got passed and approved so that we didn't have any questions going forward about our ability to reimburse the general fund for the costs associated with that piece of the project. We didn't want to get outside that 60-day window, if you will.
So simply put, the general fund is spending out some money
Yes.
for the construction project. And eventually we will get reimbursed. But this resolution actually solidifies that position that will be reimbursed. Is that correct?
Exactly, exactly. Mhm.
All right, is there any questions?
Madam President.
Let's start with Mr. Jones, since Mr. Greenspan has blown up his microphone down there. Yeah.
Now, this goes back 60 days, is that correct?
That's correct. Mhm.
Is that from today or from the passage of this legislation?
From the day it's approved by the council.
Will that capture all of the expenses, demolition, and all the general fund expenses we've put out to this point?
Mr. Chairman, or Mr. Councilman, yes, for the ones that actually are subject to this regulation, yes.
How much has that been to this point?
It's a little over $2 million at this point. Now, the other expenses that we've incurred are considered preliminary and aren't subject to this particular Treasury regulation.
Okay.
It's just that we've started seeing the demolition payments and invoices coming in, so we wanted to be sure we had it covered.
Okay, thank you.
So demolition cost is clearly a part of the whole.
Yes.
Okay. Anyone else come that way? Mr. Conwell?
A quick question. Are we on schedule to where you thought you should be? I don't know if that's an Applebaum question.
I believe we are,
In
yes.
respect to demolition and,
Yes, I believe we are.
Mr. Miller?
This is the first time I've seen a resolution of this type, and I know we've done a lot of projects where we've fronted money from the general fund with the express intent that the general fund would be reimbursed after the bonds are issued. Are you saying that this is the first time that we've done one of these projects and actually expended money on the core elements of the project itself before the bonds were issued?
Mr. Councilman, I can't speak to every other project the county's done. I'm only aware of what's happening time-wise with this particular project. And we just saw that with these invoices coming in on this demolition piece, we were concerned because when we look at the schedule, when we're bringing in the other legislation for this project and when we expect it to, we're hoping it will be approved, we'd be outside that 60-day window. But I agree with you. I've been doing things like this for 17 years now, and this is the first time I've seen it, the need for it to be done as well. And our bond counsel contacted us and said, hey, we need to think about this.
Madam Chair, to Marvin, could you, Melvin, I'm sorry, would you have Director Tewan to get us an answer about that question as to whether we've expended funds on any other projects prior to the bonds being issued?
And Madam Chairman, Mr. Councilman, if I may, it's a 60-day window. So if the bonds were approved at one point and those costs that you're speaking of were incurred within 60 days prior, then there wouldn't have been a need for this. So just so we're clear on the requirement here.
Understood. Okay, thank you.
Your man, and then we'll go to Greenspan.
So the first bill was incurred on February 18th.
That's the first one we paid, was on February 18th, yes.
Okay, so we've had issues today on several different committees about suspending the rules. So if this gets a second reading, then we could pass this on third reading on April 8th, and it would be time enough?
Arguably, yes, as far as I know. That's assuming there isn't anything out there that I'm not aware of as far as a cost. And I have been in touch with the folks in Public Works. So I believe that's correct, but I just want to, again, when you're working with bond counsel, particularly with tax issues, there's a lot of kind of belt and suspenders that goes along with projects like this, and I would put this in that category, again, asking that it be passed on second reading, if at all possible.
Second reading suspension.
Yes, sir. Mm-hmm.
Well, Madam Chair, it's come up. It seems like we're constantly getting asked to pass things and there's contracts, there's reappointment dates. That happened this morning in Human Resources. I can understand that, you know, this came up, this is important, this is a lot of money. This may be the reason why, a legitimate reason why we need to suspend the rules. But I guess I'm trying to make a point that all day long we're constantly being asked, you know, to pass something, and the contract's coming up. So we got to get ahead of the things. But I have no objection of passing this, because I can see it makes good sense that we need to have it. And that's why I raised the question if April 8th was going to be soon enough.
I agree with you, Mr. Jimana, but frequently things are given to us by the administration at such a late date that we are forced into suspending the rules. But we passed the three reading rule for a purpose, and I understand your point exactly. Mr. Greenspan?
Great, thank you, Madam President. Mr. Milner brought up a good point, and I don't know, and obviously continue, Davis, on your comments and your questions of Director Teeuwen. But this council and this county has approved tens of millions of dollars with the expectation of the funds being reimbursed through bonds. And if this is a standard protocol for us to be eligible to receive that bonding, that money back through the issuance of bonds, the greater question would either be to Director Parks or to OBM to understand where we are in the whole bonding situation. And if there was a 60-day window and we haven't exercised the provision you're asking here, where does that put us? So, Mr. Davis, if you can take that back to Director Parks and OBM to find out, does this provision apply to the other bonding monies we've set with the expectation of bonding reimbursement? My question on this is a little more broad and a little more specific at the same time. We have not seen budgets, plans, documentation on the hotel in any grand measure. Yet we've been asked to piecemeal voting for appropriations all along the way, and it continues to happen. And I've been a very outspoken critic of the fact that I believe we should have a hotel. I don't believe we should own it. It's a heavy encumbrance. When might we expect I mean, there's a hole in the ground now. There's some foundation work being done. The original conversation was there'd be 280 or so parking spaces. Now we were told that's not going to happen. So what's happening over at the old administration building? What are they building? We haven't seen plans. We haven't seen anything. Yet we're being asked to continuously fund operations. And so I mean, you know, we're talking about moving this project forward. I voted for about all I'm going to vote for, which was clearing of the building and greenfielding the property. But I think the residents of this county need to know what that hotel is going to look like and how much it's going to cost, and we don't know.
Madam President, I'm sorry, this isn't the question for Mr. Cotw. We're here on a resolution that's speaking directly for reimbursement of bonds. If this is a question you have about the budget of the hotel, I'm not sure that that's the place or the person to be responding to that.
Well, is $260 million enough?
We already,
I think that Mr. Applebaum is here, and we can address that question to Mr. Applebaum. So let's narrow in on this one question before we go on to.
Well, Madam Chair, there are a couple of comments I'd like to make. First of all, as I said at the opening, this is not standard protocol. This is not something that often happens, that you see a project getting so far in advance of when the funding approval is coming in. So I don't want it to be interpreted as something that we may not have done correctly in the past. You can't make that assumption based on the fact that it's happening with this particular project. I think the other point is, as Councilwoman Simon mentioned, this is not about funding the project. This is about reimbursing ourselves out of the bond proceeds when the bonds are authorized. So this is not, doesn't have anything to do with actual funding the project in the big picture. That's a piece that would be coming in. Our plan is, frankly, to have all these things introduced to the meeting on the 25th. And then that would give us enough time for 3 readings on all 3 of the big pieces that are coming down the road.
So what I'm hearing is we will have a final hotel project plan, budget, architectural drawings, everything next week?
No, that's not what I said.
Well, let's let Mr. Huth answer his question, and Mr. Applebaum is here, and we can have him come up and address those.
Next week, we're getting ready for introduction for next week, 3 pieces. The funding piece, which would be the issuance of the debt, the GMP with Turner, That ordinance, or, sorry, that resolution will actually have a blank in it because we don't know that number yet. We're not going to expect a committee hearing before we do know that number. So but we need to get it introduced so we can get meet the three reading requirement. Then the other piece is the agreement with Hilton for actually managing the project. That resolution will have a lot of numbers in it, most of which we think are fixed at that time. But that gives us, since we have that three reading span then, if we need to tweak the numbers throughout that next 6-week period, we can get those taken care of before final passage.
Okay, Mr. Applebaum, do you want to? Yeah.
Greg, at what date will the bonding start to take care of the costs?
Again, I'm going to speak ideally from my perspective. We introduced the 25th. That will give us time to have 3 readings before April 22nd. The plan right now is to sell on the 23rd or 24th, and we'd have the bond proceeds about that same time.
Of April?
Yes, sorry, April. Mm-hmm.
You mentioned $2 million for the past 60 days. If that's correct, the $2 million for the past 60 days, what do you expect our total bill to be before the bonding takes place?
I can't speculate on that one, I'm sorry.
Speculate.
I'm only worried about this one right now. So.
But there will be more beyond the $2 million you would expect?
They're incurring costs daily while they're working on the
Right.
site, yes. Mm-hmm.
Just want to interject on that point. So I know this legislation is for us to be reimbursed. Will we be reimbursed for everything that we've put in?
Yeah, yes, Councilwoman. The other costs that we've incurred are considered preliminary and aren't subject to the same 60-day rule. So we would always be able to reimburse ourselves for those costs.
If I may, just very quickly, and Greg knows a lot more about this than I ever will, but just sort of a point of clarification about, we use the term bonds loosely in terms of what we're doing here versus what we traditionally do. These are not general obligations bonds that are, sometimes being issued without restrictions as to their use and how they're backed. These are certificates of participation that are issued for a specific project, backed up by, by TIF, by the revenue, so I wouldn't just presume just because, the very purpose of these bonds is reimbursement as opposed to when you issue just, general obligation bonds, and where you then, through your budget, how you move accounts differently, which probably is the more traditional way. Like when the commissioners bought the Ameritrust Tower, they then issued general obligation bonds and reimbursed themselves for it. That's not what we're doing here. These are certificates of participation for a very specific project.
So, Madam President, so when, maybe this is more to Mr. Applebaum, but when will we find out the total cost of the hotel?
Mr. Huth is not in a position to answer
I'm
that.
going to punt that one.
Yeah.
Well, then how do we know the 260 is enough?
We know that's a not to exceed number as far as the bond issuance goes, at least at this point.
So if the project was coming in greater than 260, then is it the anticipation going out for another bond, or the reserves would cover it?
Well,
you must have some idea where the 260 came from.
The 260 is our outside window for the bond issuance. Now, we've got other resources that we'll be bringing to bear so that the actual issuance of the debt will probably be less than 260. But we think the 260 is the outside window at this point for the bond.
Right.
All right. Mr. Applebaum, do you want to chime in? Yeah, you've been sort of.
Yes, I have a couple slides that might help if I could
Okay.
take a minute.
Guarantee max.
Put this up. There's 2 of these.
Which one? No, I don't. I just have 4 slides.
Now, Mr. Hairston, listen carefully because you're going to be tested on what Mr. Applebaum says. He'll have lots of PowerPoints and things, right?
I want you to know that I came in on the red eye this morning.
From where?
I was in Maui.
Oh, I was wondering had you gone on your vacation yet? Wow.
Well, the good news is I went on my vacation. The bad news is while there I contracted pneumonia.
Oh, wow.
So I was in Maui, recovering. So I'm better now. Thank you.
At least you weren't on Flight 370.
That is a piece of good news. Thank you. So.
I mean, our whole project would be over.
Well.
Hell, right?
So what I thought I would do, and I wasn't exactly sure how much, I just have a few slides, and what I wanted to do, and I'm mindful of the questions that Councilor Greenspan had, I wanted to give you not so much answering all the questions now, but a roadmap to how and when, what the process is to get this answered. So I'll take a few minutes to go through this. In terms of the project design schedule, what you see before you is sort of where we are. And I'll go through this in a little bit more detail, but up until now, we've gone through the process. We had the initial outreach meetings. In the design process, as you may recall, we go through schematic design, design development, get to a guaranteed maximum price, which is based on design, which is basically 35 to 40% complete. We get the guaranteed maximum price, and then we complete the detailed working drawings. I went through that with you before. So just as a reminder, in the fall, we went through schematic design. We did make a presentation of schematic design to council. So you may recall we had the architect here, and we showed you generally a lot about what this hotel would be like. And you've seen a lot of that. Not the excruciating detail, but the generalities. And there's been some modifications as we go through. Nothing dramatic, nothing that would show you a different building, but pieces and parts within the building have been modified. We've gone through our public outreach meetings. We've now been through 3 public outreach meetings. And we are at the point right now where we have essentially completed the design development phase. We have that package has gone to the design builder, and they are in the process of delivering their final proposed guaranteed maximum pricing. Now let me explain what this is really about. We have continuously been working with all of the parties day after day after day on components on pricing. Today, by way of example, there's a very large meeting with all hands on deck on the curtain wall, the outside of the project, how that's designed, how that looks. The process is a continual process of trying to reconcile scope, budget, and schedule. So at every point in time, we have design concepts, we estimate, we figure out where those estimates are over. And in this process, they're always over. You're always taking concepts, you're always getting estimates, you're always driving the number. We're meeting, we're reconciling, we're making modifications, and this process has been ongoing for a few months now. Where we're at right now is a more formal part of the process. So what's about to happen is with all of the modifications, everything that we have developed, on April 7, we're going to get the final, I shouldn't say final, but we're going to get the formal guaranteed maximum price proposal from the design build team. It's going to say, based on the drawings here and everything you've shown us to date, this is our price, including these qualifications and assumptions. Now, I'm going to tell you when that comes in, and that number will be higher than our target. It's always higher than the target. You then spend the next several weeks, and I'll tell you about the process reconciling, going through step by step, inch by inch. You've priced this at this. If we give you this information, how can that be modified? How do you adjust this allowance? Because for every element of the project, there's different choices. There's, this version of lighting fixtures, this version of lighting fixtures. So there's this process. I've referred to it as making sausage, but that's exactly what we go through. It's meetings every day for about a month. So what happens is we get the GMP proposal on the 7th of April. We start this reconciliation process, and we've been through it, by the way. But the final reconciliation process is basically those days between the 7th and the final done deal, which is on or about the 22nd. And you'll see in a minute how this is all lined up to be completed on the 22nd. Thereafter, by the way, we do have a formal submission of design to Hilton. This is a formal thing because Hilton's at the table with us. So if the Hilton folks are approving everything along the way, there should be no issue with the formal approval that comes in May. With the GMP, we then commenced the process of document preparation. We are still on board for substantial completion April 1, and we're still on board for a hotel opening on June 1, 2016. That's one thing that we've cast in stone. Sometimes budget goes up and down, scope goes up and down. The one thing that we have held firm is schedule. That's the one thing we're not permitting to move. Scope may move, budget always moves, but schedule is intact. So just to tell you a little bit about what's going on the site right now, and then I'm going to come back to where council will be involved. Right now, and we'll have some meetings and hearings about this, we've been working very hard. We have an ongoing inclusion program, which is a topic for another conversation. The abatement was completed on or about January 24th. The demolition was completed on or about the 28th of February. And excavation has actually been essentially completed on or about March 14th. So we've abated, we've demolished, we've excavated. To some degree, we've had less excavation activity than we thought we would have because we modified the design a little bit on the lower level that actually required less excavation. There'll be more foundations, less excavation. We are now in the process of pre-coring for caissons. So the next big activity on the site is drilling for ultimately deep caissons. We had, one of the unfortunate issues that we have with the project is we had hoped, and I've mentioned this before, we were looking to try to avoid necessarily the cost and expense of deep caissons. We looked at different types of foundation systems, but from an engineering point of view, we are required to use deep caissons. So we are doing the pre-coring for the caissons. We're obtaining the caisson permit. The caisson installation will be about a 3-month operation. That's going to occur in April, May, and June. Now, I will tell you that just to get some costs in your mind, the combined cost of demolition and excavation probably somewhere in the vicinity of $1.2 million. The cost of the caisson installation will be in the vicinity of $8 million. Wow. Now, having said that, though, because that work will commence, because that's April, May, June, payment for that work comes at least 30 days later, about 30 days later. So that's June, July, and August. So that's all going to be captured. I'm sorry, May, June, July. So that's all going to be captured after the bond issuance. So that's going to be captured by the bonds. That's not going to be substantially pre-funded, to get to the question of how much we're spending. But the next big expenditure is caissons, which is a large, expensive proposition. And then after caissons, what happens is we start with the actual foundations, which are spread footers, pile caps. Foundation is completed, then you'll see the building start to go vertical. But that's down the line. So in terms of contracts, obviously you'll see some subcontracting out there. You see the site. You know that we had abatement, demolition, caissons. We already have entered into preliminary contracts because these are long lead time items for the exterior wall design. We have our electrical design build contract underway. We have our steel design build. These are long lead time items. You can see the names of some of the players there. Ultimately, as we did for the convention center, we'll start showing you the list of subcontractors, the list of SBEs, minorities, as we fill in who all these players are. Just so you'll know, just a little bit of a look behind the curtain. I just picked a few items out just so you'll understand the kinds of things we're thinking and talking about. So what are the things that we've been focused on, along with a million other things? Well, one thing has been this deep foundation, the caissons. When we went to deep foundations and caissons, that became a large issue. It's a schedule impact that we have to absorb. It's a cost impact. We have mitigated some of that by reconfiguring some of the lower level. So some of what you saw on the lower level, and you know about the parking, there's parking that's not there, as you mentioned. We've done some other reconfiguration on the lower level to help save some money and actually make the building more efficient. I just threw in one thing here, one thing that's a challenge here. This is like one of the little things you think about here is the laundry. A full-service laundry has to be located down there. We had a choice. We could do a full-service laundry in the building, which is what Hilton wanted, or we could send out. And we could actually have a service that went out for the laundry, have laundry come back and forth. we did an extensive analysis of that, found out that ultimately, while there's a front-end cost, ultimately we save $500,000 a year ongoing by actually doing the laundry service in the building. And it may be that this laundry is a center to do other laundry, not just for this hotel. But we did the in-depth analysis and found out, yes, we should have an in-house laundry to take care of the services. That was part of Hilton's program. They would have considered outplacing it to save some construction costs. But at the end of the day, revenue-wise, we would have been further behind. We're better off to do it. But we have to locate it, and that's the kind of challenge, everyday challenge that we're looking at. One of the things that we are constantly looking at is maximizing the subcontracting pool. The fewer subcontractors and contractors that are out there bidding, the less competition there is. And one of the challenges we have, we know that we're in in Cleveland, primarily a union environment. We have to maximize the number of contractors who are out there. The more contractors, the better pricing, also the more opportunity. So that's one of the things that we focus on. You're all aware of the fact that we are, schedule is very important for this. We are to maximize our ability to get done by June 1. It does require some acceleration. We are working, we do have to work some overtime, we do have to work some second shift, we do have to work some weekends to make that happen. There's a cost involved. We also have to get some noise ordinance relief. We have some evening operations. There's a noise ordinance in Cleveland, so we have to make sure that we can work well with the city to carry on the activities we want to, getting some relief from the noise ordinance while not violating, while still working efficiently and quietly so that we don't upset citizens. But those are some of the challenges we have. Another challenge that we're continuing to work through is the parking challenge. What are we doing for district parking? And that is an ongoing study, an ongoing investigation. Some opportunities to talk to you about. Aside, and everyone knows about some of the reasons for doing the accelerated schedule. You've heard about the possibility of the conventions, but we are finding out that by getting this done in June, going back to the convention center, going back to others in the community, going back to Hilton, we do have a lot of opportunity. The earlier we get this hotel open, the sooner we start getting revenue generation from it, the sooner we start to be able to bring other events in, and we're doing some pretty good analysis of what that is. So we do have a big opportunity. Completing this early does have good opportunities for us. One thing I did want to mention to you, the last time I think I presented the concept to you, I think I told you about a meeting space up at the top of the building, one floor down, and we thought that would be a pretty good place where people could do meetings, private meetings. We have actually advanced this concept a little bit for a couple of reasons. Number one, we felt that because this is a public-supported project, that maybe we could take that space from private to more public. We also thought we could get additional revenue generation. So right now, the current plan, we've moved that space up to the very top. And right now, that's going to be a bar. That's going to be a public amenity so that you could go up there. You'd have to get a reservation because we think it's going to be a pretty hot place. But it'll be a place that any citizen could go up, make a reservation, get up there, and get to the top of this building at what should be a tremendous space in Cleveland. There's actually some great benefits of doing it this way. Number one, we actually think it's going to increase revenue generation. Number two, it actually helps us with our exiting strategy in terms of code. But so we think we're going to have a top of the building bar type facility, which is in a lot of other cities a tremendous amenity to have that at the top of a building like this. We're also now considering, because we want to support the overall approach of the project, including our Global Center for Health Innovation, we are now considering doing some special things in a certain number of guest rooms, which will be health-oriented guest rooms. What will be in those guest rooms, what the amenities are, we're looking at right now, but we think that one special brand, one special thing we can do for this hotel for our guests is to do some special things in some rooms that are going to have a health orientation. I'll tell you more about that later, but it's pretty exciting, some of the things we've looked at and some of the ideas that are coming out there to differentiate the hotel.
Like you have a treadmill in your room or something?
Vegan food only.
I won't get into what these will be yet, but I've seen it, and we'll make the presentation. This is actually the reason I wanted to come up here. This is the chart that I want everyone to keep in mind. And I'm mindful of the statement about making sure we have 3 readings, making sure you have ample time to look at things. So right now, I'm going to tell you that there are 3 critical paths that all merge together. 3 things that everyone is working furiously on right now to get ready. One of them is the Hilton Qualified Management Agreement, the QMA. We have a team of individuals who are working on the deal with Hilton. And I have to tell you, this is a very complex proposition. There's a lot of tax law involved. It's just highly complicated. We're making great progress with Hilton. It's a lot of effort, but this is one of the 3 things that has to come together. And the thought process is that we will introduce, and you'll see a resolution a week from today. Now, that resolution will have a lot of economic information in it. And ultimately, as we go through the discussion process, we'll make a presentation in depth as to what that is all about. What we've laid out here is a process of of introduction on the 25th, a second reading on the 8th, the ability to have a committee meeting. We've suggested a date in there, the 15th, obviously. If you want to modify some of this or need to, or feel you have more time, that's up to you. And then this provides for a 3rd reading on the 22nd, so it provides for 3 readings. So number 1 is the QMA, the Hilton Qualified Management Agreement. The second one is the guaranteed maximum price. And this really gets to the issue of how much, what's the scope, and it really gets into what all do we have, what all are we buying, what is the guaranteed maximum price, the project budget, because the key to the project budget is the guaranteed maximum price with the builder, because that's over $200 million of the whole thing. That's the big nut. That is what makes or breaks how we do this. So we're going to introduce the resolution on the 25th, but that resolution will still have a blank in it for the final number. And as we work through this, that final number gets developed with the final scope. And then the third thing is the bond financing. This right now has the bond financing introducing the resolution on the 25th. It has the second reading on the 8th. This provided for draft discussion and a 3rd reading on the 22nd. I don't know whether that needs to be modified, but that right now was the plan. And Greg, are you thinking of a modification based on what you said of the 3rd line, or you still think that's intact?
No, Council, we believe that if we can get it in on the 25th passage, that if introduction on the 25th, and if we get it passed on the 22nd, we'll have time to get the underwriter is going to be marketing the bond between that 2nd and 3rd reading, and then we'd be in a position to sell that on the 23rd or 24th.
One of the great advantages to this and why this is so important, I think I mentioned this maybe the last time I was here, but interest rates, what happened when I first talked to you about the project, interest rates were at a certain level. As we continued to talk through the project through the fall of last year, interest rates actually climbed. It climbed to the point that the impact and projected impact on the project would have probably cut over time $10 to $15 million out of the project. Well, those interest rates have come back down. And right now, we are in a good place on interest rates. I haven't looked in the last 2 weeks, but the last time I looked, they were like in the 4.4 range, and we had projections going up above 5. In fact, up to as high as 5.75. And every basis point represents about $200,000 of either benefit or a problem. So that's very important to us. So we think that if we can keep this in this time frame, we will be in a very beneficial position. And it may be as much as from one of the last projections we did, it may be as much as a $10 million savings. Now, that's not to say that doesn't affect the budget. I mean, the budget's still the budget, but it's the available funds to take care of the budget. So that's why that's important. So this is sort of so what I'm trying to say here is that we're about to enter into crunch time for all of us working on the project, and crunch time is really going to be between now and the 22nd. And within that time frame, we have a committee meeting on the 15th. There'll be a lot of information and a lot of work to do. And we'll work with you as council as to whether that's sufficient, whether you want to set up another committee meetings or whatever you want to do, because we'll have a lot of information to convey during this time frame.
Yes, Mr. Miller.
I appreciate the information. And just want to make a comment that the schedule that you put forward technically complies with the 3-meeting requirement, but does not comply with the spirit in which it was designed. The way it's supposed to work is that you have the first reading and that you have the committee work in between the first reading and the second reading. And when you have the second reading, the work is substantially completed, and you have the second reading with the completed legislation just for it to be out there to the public in case anyone has any feedback, comments, suggestions, or whatever, and that at the third reading, at most, you might make a few minor technical changes, but what we have here, particularly on the GMP, the schedule that I saw, it looked like we won't even know what the final GMP is until on the 22nd or a day or two before, and it looks like most of the committee work and a lot of the details would not be available perhaps until the 15th. So I don't know how much of a problem any of my colleagues consider this to be, and maybe you got to do what you have to do, but I just throw that out there for what it's worth.
Well, it's part of the problem is that we bought into this rapid schedule proposed by the administration, and now that we're into it, I don't think that we have any choice. I mean, we had an opportunity early on to say, do we want to fast track this and go with this, or do we want to say, we don't think we can do this by June of 2016. We bought into the proposition that we're going to fast track it, and now that we did that, I think we're at the point of no return. We've got to go with these schedules.
Here's what I could offer, and let me be the first to tell you that and you are correct, all these line items are extremely intensive work, but it is the second line item which is the most intensive in this period. And this is really driven by when the design documents are ready, how much work has been done. It's really driven by the schedule. You know, if I could give you more information, a lot more information before that second reading, I would. I'll be honest with you to say that the information I will have, it's not that, you know, I'll be developing this information very quickly as well. Now, the one thing I will say to you, if you have an interest, these reconciliation meetings will be going on. There'll be a series of these meetings. There'll be day-long meetings. And if at any point in time during this process, if any one of you want to come attend portions of the meetings, hear the discussions, understand these things, we can, you know, you're welcome to do that. You know, the issue is coming back here and presenting, because these things are very intensive and there's a lot of work going on, and they change, it's going to change hourly during these weeks. But I can invite you to come, I can invite you to observe, I can possibly give you an update if you want me to before April 8th, just on the status of the process. I can give you as much information as I can, but ultimately the GMP process is a very deliberate process during this period. And what we're trying to do is two things. We're trying to take advantage of getting the bonds you know, sold, but we're also trying to take advantage of doing everything necessary to maintain this schedule that has a completion date in April of 16. And this is what we need. This is pretty much the deliberate nature of the schedule that we need to make that happen.
Mr. Greenspan?
Thank you, Madam President. Just point of personal privilege, Mr. Applebaum and I had a chance to have some us time on a flight to Atlanta a few months ago. Poor Jeff had to sit next to me for the whole flight, but I saw him try to request a seat change, but it didn't quite happen.
That's not true. Okay.
So going back to my original question, then I want to come back to this. What is actually being built? What work is being done on the site now? Like I said, we haven't seen plans, but if you're putting caissons in the ground, there must be some schematic, some
Well,
drawings.
there are, let me say this to you. There is schematic design, and we did do that presentation. There is design development. And if you want to see the state of those, let me say it this way. As you understand, in order to do the caisson design, we know enough about, there's enough of the building design which is in place structurally, which exists. Now, I can share with you, I mean, there is a design development package that we can share with you, and you can look at that. The only thing I'm going to tell you is that that package, which is out there and is the basis of the caisson design, it is still subject to change. Not major change, not change that changes the caissons, but until we reconcile this process on the 22nd, there are elements of this that are still going to change, and part of that is because there are options within the package. In other words, there's a design, and it has option A, option B, option C. But if you want to get a more detailed view of that, I can give it to you. Now, we have made a presentation of that design development. We did do a presentation here. It wasn't as detailed as you would like. And we also did do a presentation to planning. So this is out there, and we can give it to you. And if you want to come to my office and view it, you can look at all that information. It's there.
The other concern, Mr. Miller hit it on the head. So just so I'm clear, on the GMP, and Mr. Miller was right, you know, we operate at our own timetable, not a timetable mandated by us, and that's Mr. Germana's point about being forced into first reading suspension or even second reading suspension. So with that said, you know, you know where I stand. I'm not supporting this period, but I think it's important for my colleagues to at least have an opportunity to understand what the cost, and the public, what the cost is. So would the opportunity, I guess that, you know, let me leave it there. I mean, we don't know what the cost of this project is. To the council president's point, this item has been brought along for a while, and the opportunity to say no still exists. In my opinion, the opportunity to say no exists on this vote on the bonds. And if the council decided to vote no on the bonds, then the project doesn't move forward. So I don't want my colleagues to feel as if they've been involved in a process to which we've gone too far. In my opinion, the gone too far is voting for the bond. The county has expended money. The county's probably expended about, as best I can tell, about $40 million, or committed to spend $40 million between bond council, architectural fees, and the remediation and demolition of the previous building. But
I believe that I believe it's substantially less than that, but we can go through that.
But we are anticipating another presentation from
Yes.
Mr. Applebaum, and I think we're talking the 25th. That we have, I don't know if we have, do we have a committee of the whole already set for the 25th? But we can.
I had not.
Yeah, okay.
Yeah, I will say this to you. I had not. The 25th, we were going to just have the first reading of those three resolutions. I had not anticipated a presentation on the 25th.
Okay.
I know that's a day I cannot personally make, but I can make other days that we can set up.
Okay. Yeah, we have a meeting 2 weeks from now on the voting, so we could do something on that day too. There would be the off day, which is that, what day is that, the 1st? April 1st. April 1st.
Okay, we could. I would really rather not make a presentation with Mr. Greenspan on the hotel on April 1st, but if I have to, I would. But I can work with you.
We'll work with you on the date.
But
Yeah, we'll work with you on the date.
During this time frame, as much as you need, as you know, I'll provide it as we can.
Okay.
President, if it's April 1st, we can have a Daryl Issa microphone. A Daryl Issa microphone.
I don't think.
You get that? No, Daryl Issa in Congress. Mr. Greenspan knows what I'm talking about, right?
All right.
Madam President?
I'm a little slow. Okay, go ahead.
Just had one question, Jeff. I know we talked about a rough dollar amount of $260 million, and I know we have our process for our readings and how we're used to doing things. But give me a sense with this GMP, what does it take to craft this? What are the parameters? What do you? just give me some sense of what it means to come up with the actual GMP.
Okay, so let me try to answer the question. First of all, and once again, this is a negotiation that we're having with the design builder right now. Obviously, the GMP is less than the 260. The GMP is a component of this. The GMP will be a number which is in the low 200s, okay? It would be delightful if the GMP was at 205. It's not going to be at 205. But there's a range that is, plus, 10% in that number, okay? And the real issue is getting that number to the right scope, and that's really the where we're at right now. That's where our focus is. Above that, then there's other costs and expenses of the project, but the hard nut here is that number, which is going to be in the low 200s, all right? And I would tell you, this is a broader range than it will be, but I would tell you, if you want to take 205 and you wanted to add 10%, that's the outside number, but it's not going to be, it'll be a different number. It'll be in that range, though. That's just a thought process. Now, what does that mean? That GMP includes, first of all, it includes all of the fees of the design build team, which is Turner, Ozanne, VAA. It also includes their architect of record, VOA. That's all in there. It includes the estimated but guaranteed cost of all the trade contracts, all the construction. It includes contingency, their contingency. It includes general conditions items. It includes all the staff. Basically, it's the full cost of construction. That's what's in that number. And that's what's going to be guaranteed by the 22nd or 23rd. So that's what that is. And what it doesn't include, it does not include the furnitures, fixtures, and equipment, or the owner supplied stuff that comes in later. In other words, it doesn't include tables, chairs, dishes, artwork. That's all on top of it. That's part of what we do with the procuring agent. It doesn't include certain other soft costs. It doesn't include certain startup costs. All right, now, where we are in terms...
Does it include unforeseen issues, like with the convention center where we had small concerns? When those come up, is that included as well?
Well, so let me explain that there's three types of contingencies in this project. Number one, there is a contingency that will be within the GMP for basically that will be the design builder's contingency because they will have unforeseen things. There are two more contingencies. Within the plus or minus 260 budget, we will have a contingency, and you may recall this was exactly the same way we did it on the convention center. Mm-hmm. And then quite honestly, and I haven't gotten into this number, when I talk about a 260 budget, I don't do that without a contingency either. So when we looked at our overall financial plan, there was a contingency above that budgeted because the 260 is a target. And this gets to Mr. Greenspan, who is very smart about these things. He's saying, I've heard the 260, what's your number? And right now, the 260 is the targeted number. Yes, there's contingency above it, which is within the financing plan. Where we have to be, we'll know more about that in a few weeks. But there are three levels of contingency. There's the contingency within the GMP, there's the contingency within the target, and there's the contingency which is the ultimate, above it, that we don't get into, but that the financing plan supports.
Okay, thank you.
I think does anybody have questions, Mrs. Stein?
Question about the public space, that bar. What's the capacity going to be with that?
There is an answer to that, and I don't have it right now, but I can get that to you. My Ellis Katz has all that information. Actually, there's been a lot of work on this in the last week when I haven't been around, so I'm not even I don't know the final on that.
I think it's really important the public has access to that, so I appreciate it. Hopefully it's going to be large enough, not more than...
Bar, it's not a restaurant, is that right?
Food, too, with a terrace,
well,
right?
It's going to be a bar. It's going to have a terrace. There's obviously not going to be a full-service kitchen, but I'm sure you'll have bar food up there. But if you've gone to a few other major cities like Chicago and other places, these rooftop bars in their major places, they're the great spots in downtown areas. And it'll have a wonderful view. This will be the best view in Cleveland.
All year round?
It will be all year round. Now, whether I don't know about the terrace all year round, but there'll be a terrace and the bar will be all year round. These are all details.
Okay. If there's nothing further, is there a motion then to pass item 0064 on to the regular agenda for passage under suspension of the rules?
So moved.
Second.
Moved by Mr. Jones and seconded by Ms. Simon. Any other discussion on this? All right, all those in favor indicate by saying aye. Aye. Opposed? The ayes have it. This item will then be on for, sorry, Mr. Greenspan is nay? Yes. Okay. That's right. And so we have a quorum. So this will be on for the next Tuesday, the 25th? Yes. All right, thank you, gentlemen. Any other, anything else, any other miscellaneous business?
I actually have one other question. I'd like to know, you've had 3 public outreach meetings. Can you give me a sense how the attendance has been? And
My understanding is it's been very good. The outreach program is working very well. We've also, in the last few weeks, we've also focused on, we took a look at outreach the first time around, and we took a look at those areas where we thought we could improve. One thing that we've also been working on is outreach to the Hispanic community, and we have, in the last few days, we've put in some new pieces in place that you'll hear about that are going to enhance our outreach to the Hispanic community. So my sense of it is that is all going very well. I will tell you, though, and as I mentioned, I've been out of touch for the last week, so I'm going to be getting updates on all this stuff. And but from everything I've heard, they've been very successful and very well attended. So we are very confident that we'll have great success on this. One of the things we're also looking at very carefully is how we're going to address the apprenticeship program. Keep in mind, we now have this 4% low income, and that really, that's all tied into training, apprenticeship, where you go with that, and that's another area that there's a lot of focus on right now.
Great.
So my thought would be that at some stage in this process, either as part of or independent of everything else, we just come back and report to you on the inclusion plan, because that's important, and I think that justifies some time with the experts who are working the plan to come in and talk to you about how it's going.
great. If you have anything you can send me now, send it to our clerk for all of us. I've gotten some calls from the Hispanic community that I'd like to be able to respond.
Okay, that's great. I will do that.
And any public comment unrelated to the agenda?
No, Madam Chair.
All right, so nothing else for the good of the order, we stand adjourned.